forgive me for saying this, but this is all Kabuki theater. Because at the end of the day, you don't have to follow the guidelines. The guidelines now are creating unwarranted, not only creating unwarranted disparity, but they are also helping to obfuscate the whole sentencing regime when part of the purpose of the guidelines was to bring transparency and rationality. But none of that shit matters anymore.
Right.
So it's like I keep coming back, it's Kabuki theater. We're just doing it
Right.
about a Potemkin village, if you will, whatever the
Right.
metaphor.
Which in
It's very
my
frustrating.
mind is really validates the essence of our work at sentencing, which is to say, screw the guidelines. They don't give you any clarity.
Yeah.
Nothing in sentencing makes sense except for a well-developed, well-told mitigation story, period.
Over 1 million Americans face sentencing every year, and it will be the most important day of their lives. But we don't fully understand the system, how broken it is, and what we can do to make it better. I'm Doug Passon. I'm a 25-year criminal defense lawyer and a sentencing expert. My goal is to bring more awareness, more fairness, and more humanity to the sentencing process. So, are you ready? Then let's get set for sentencing.
Hey everybody, Doug Passon coming to you from Studio 3553 in Scottsdale, Arizona. This is episode 104 of Set for Sentencing. We are going to be talking today about the new guidelines that went into effect this month, November 1st. And I have my good friend and colleague and returning champion, Mark Allenbaugh of sentencingstats.com and federal guidelines guru to walk us through all of it. But before we do, I just wanted to let you know that typically I take December off from the podcast. So this is going to be the last episode, at least the last new episode of 2024. We'll be back in 2025 with a whole mess of new content. I may post a thing or two in December of interest, maybe an older episode that I think is one of our greatest hits or some other stuff. So stay tuned. But this is going to be the last one of the year. And I can think of, well, I guess I can think of better ways to end the year than talking about the guidelines, but what are you going to do? The guidelines are still the guidelines.
Oh
They're
yeah.
still here. We got to deal with them. And as you know, if you've been paying attention, November 1st is always the magic date where if Congress doesn't do anything to act on the amendments that the commission sends over, then the changes go into effect. So there are changes to the guidelines that will impact you in your sentencing, guaranteed. So we've got to talk about it, and let's dig in. You have prepared a lovely little PowerPoint, only 4 slides, so I'm impressed with that. But where
Yeah,
do we
only
start,
four.
Mark?
There we go. So one of the things that also happens to be, and I wanted to give a shout out to the guidelines and the commission where I used to work 100 years ago. It's the 40th anniversary of the Sentencing Reform Act. Actually, it occurred on October 12th. The Sentencing Reform Act of 1984 was the legislation that created the commission, which created the guidelines. And the whole purpose behind the guidelines, as we know, was to try to bring some rationality to sentencing. With the overarching principle being similarly situated individuals should be treated similarly, so that you didn't have all this wide, crazy disparity in sentences all over the place, and eliminate stuff like racism and sexism and all the other prejudices out there to the extent possible, and to make sentencing a more rational and really principled endeavor on the courts.
So how's that working out 40 years
Yeah,
later?
well, it didn't work out. So it was a good start. And what's really interesting, what I wanted to share first, because I am the stats guy and I like numbers, is just how much of an impact. Before we get into the fact that it really didn't work out and sentencings are all over the place, and frankly, we've discussed that in the past. I mean,
Yep.
ultimately, really, what it is the guidelines were intended to do these principled things, eliminate unwarranted sentencing disparity, bring certainty to sentencing. That's why they got rid of parole, and make sure that the sentences were proportional to the seriousness of the offense as well as the criminal history of the offender. None of that worked out. They did create guidelines that supposedly took that stuff into effect, but it was the guidelines turned out to be so complicated, so confusing that it inevitably led to a lot of disparities. And this was before the guidelines became advisory, which was actually 20 years ago in Booker. And we're going to be celebrating the 20th anniversary of Booker on January 12th, 2025. So there's like a lot of anniversaries and a lot of change going on now with the commission. But look, or with the guidelines, I should say. But looking back on the guidelines as a whole, what's really interesting to see is how impactful they have been. So since the inception of the guidelines, the first guidelines did not go into effect until November 1, 1986. But since that time, at least, really more than 2.2 million people have been sentenced under the guidelines for a total sentence. All those sentences that they've received combined were for 9.5 million years of custody for those 2.2 million people. And during that time, it has cost us over $250 billion in 2024 dollars. They put it forward, $250 billion just to house them. That doesn't take into account all the money it takes to investigate the case, to prosecute the case, all the front end stuff. It doesn't take that into account. This is just to house them in the Bureau of Prisons. We have spent over $250 billion to put 2.2 million people in prison with, unfortunately, very little to show for it. Right now, when the guidelines were first created, there was only about 30,000 people in federal prison, and it was rather stable. You had, going all the way back to the 70s, no more than 30 or 40,000 at most in federal prison at any given time. Now as of last week, we're at 143,000 in federal prison, and that's down from a high of around 210,000 about 10 years ago.
Wow.
Right now we're housing 14,000 additional people are in community or home confinement, and so they're still under the review of they're under the supervision of the Bureau of Prisons, but they're just not in a prison. They're in community confinement or home confinement. 110,000 are on supervised release, and 12,000 or almost 13,000 are on probation or parole. And that's a really interesting number there, because that shows you that less than 10% of those that have been currently sentenced are on probation or parole. Prior to the guidelines, that number was closer to 60%. So the guidelines have also not only put more people in prison, but it also has changed the default sanction from something other than prison to prison. Now pretty much everybody, not everybody, but a big chunk of people now go to prison, and they otherwise would not have 40 years ago. And now the BOP, the Federal Bureau of Prisons, U.S. Bureau of Prisons, houses more inmates than any other state. And that's, I mean, by like Texas, California, et cetera. At 100, the next closest state is Texas, and they're like at 130,000. And then California is at 120,000, and it goes on down from there. If the BOP were its own country, it would have the 13th largest prison population in the world.
Wow.
13th out of 185 countries.
Wow.
So this is significant. And a lot of that has to do with the guidelines, because the guidelines keep putting people in prison for longer and longer and longer, even though they're merely advisory. 96, as of last week, 96 of the 187 BOP facilities that house inmates are over capacity. That's ridiculous. That means over half of the BOP facilities are over their rated capacities. And just to wrap this up really quick, so there's 44 medium security facilities that the BOP has. Those are averaging 128% over their rated capacities, meaning they're 28% over capacity. And these are medium security facilities, which, as you know, Doug, they're not going to have the first-time offenders in there. They're not going to have the nonviolent guys. These are a lot of them are recidivists, violent offenders, very serious drug offenders, or recidivist sex offenders. So some very dangerous individuals are in these facilities, and they are the most overcapacity. They're at 28% overcapacity, the most that they have ever been, and growing.
Mm.
One of the things that happened during the pandemic is the BOP closed all of its private prisons, and there were
Yeah.
13 of them, and those closed in the course of 2 years. And there was over about 30,000, or I'm sorry, about 15, 16,000 inmates in those. And all those inmates had to be squeezed into what was left, the regular BOP facilities. And even those BOP facilities have continued to close over the last couple of years. Less money is going in. There's less retention of corrections officers. It's at the most dangerously understaffed and overpopulated position that the BOP has ever been in, and it is getting worse. And this is nothing new. The BOP has been like this for years, and still Congress is doing nothing to to expand it and make it more humane, et cetera, et cetera. This is what
Yeah.
we're
Yeah.
seeing here. 16 of
Well,
the high. I'm
yeah,
sorry.
go ahead. Go
Okay,
ahead.
16 of the high security facilities, the 16 high security facilities, they're at 121% over capacity. The low security facilities, there's 36 of them. They're at 112% of capacity, meaning 12% over their rated capacity. There are 19 administrative facilities. And what those are they're really high security facilities also, but those are your federal medical centers and things of that nature. And there are 19 of them, and they are averaging 99% of their rated capacity. So and that's just average. So some are actually over. The only facilities that really have room on a regular basis are your minimum security facilities, your camps. And
Hmm.
that's where a lot of your white collar offenders, your first time offenders will be sentenced to. But at least those are the only that's the only security level that has any room. But that's just average. There are many camps that are over their capacity too, but on
Yeah.
average, they're only at 73%.
Well, a
So
few
yeah,
things come to mind when I hear all those stats. So, and you touched on it, but the human cost behind all those numbers is
yeah,
just abysmal conditions and continuing to get worse. So, you mentioned the billions and billions of dollars it costs to do this, but they're underfunded, they're
yep,
understaffed. They don't have enough guards. They don't have enough medical. They don't have enough psychological. They don't have enough programming. And that means it's a dangerous place, not just for inmates, but also for the
yeah,
staff.
yeah,
I just saw an article this week about assaults on staff are on the rise. And dysfunctional is an understatement and dehumanizing. So
yes.
this is bad because we keep sending people to prison, but yet we're not taking care of them.
What we need is smarter sentencing, and that's ultimately what we should be looking at. They're spending way more money than they normally would because these facilities are so decrepit and so overcrowded. They are just using band-aids all the time. It's just management by chaos, management by trauma, and that is the worst way to manage anything. Even Elon Musk can tell you that.
Yeah.
So
Yep.
so
Well, and the last
um
thing was when
yeah,
you talked about how many people are on supervised release.
yeah.
People
Tell
don't
me.
quite understand in the federal system. In the state system, one of the worst things a client could ever hope to get at sentencing is what they call a probation tail. In other words, if they
Mhm.
get sentenced to prison, when they get out of prison, there's a small period of community supervision, parole, equal to 1/8 of your sentence, but they're not on formal supervision like probation. And if they get a probation tail, that's the worst because it's not easy, right? But in the federal system, almost everybody gets a probation tail because
Yes.
they get supervised release. So if you go to prison, you're virtually guaranteed to come out and be on some form of supervision on average for like 3 years. And I'd just be curious about the cost of that. I mean, think about how many more probation officers you have to hire and the supervision costs and the programming costs and all that stuff. So, you know,
Well, that's a good question, because supervised release, that's handled by the courts. So that's not under the purview of the BOP anymore.
yeah,
So that's right. Unless they are under, you could be under on home confinement under the BOP purview if you haven't formally finished your sentence. The home confinement can be part of your sentence too,
yeah,
without getting into the weeds on all of that. But once your sentence is over, you go on this probation tail that we call supervised release. But now that all comes out of the budget of the judiciary, which is also strapped for cash. But I
right.
mean, your point is well taken. It costs money there too. And by the way, on supervised release, those 110,000, over 30,000 of these individuals are going to have their supervised release revoked, and they'll be back in prison.
Yeah.
That's been a steady variable, if you will, for the last decade. About 30% of all individuals on supervised release end up getting the supervised release revoked, meaning they're back. They have to go to prison again. And
Yep. Saw it
now
all the
that costs more
time.
money. Now we got to
Right.
find space for them, you know?
Yeah. And a lot of the time they'll get revoked, they'll do more time in prison and they'll come out and they'll still be on supervised release. They'll start the clock running. So it's just a kind of a ongoing vicious cycle.
Yeah.
Boy, well,
Yeah.
so we've talked a lot about this in a lot of podcasts about the guidelines being a total failure, but they're still here. So what's new?
So what's new? So this is as you can see, the 2024 manual that would just published on November 1. You can get it at the commission's website, ussc.gov. And you can pull down the full PDF of it in one file, or it has all the sections and everything you can take a look at. So
I'll put the link in the show notes for that, by the
yeah.
way. Yeah.
There's about 9 new changes, but these I wanted to highlight the 4 big ones, which I think are going to have the most impact on sentencing going forward. And the first one is that that acquitted conduct is no longer considered part of relevant conduct. So if you've been acquitted, traditionally, as odd as this sounds, and we've done podcasts on this, if you've been acquitted of something, you're charged with 2 counts of money laundering. You're acquitted of one and convicted of the other. At sentencing, when you're sentenced on that 1 count that you were convicted of, all that other money you laundered on the acquitted conduct can still come in and be used to enhance your sentence. And everybody has been thinking that's really unfair and silly and da-da-da-da-da for years. Supreme Court wouldn't touch it. Commission wouldn't touch it. Finally, they kept going back and forth like a hot potato, and the commission finally did something about it, but it's kind of weak sauce. What the commission said is you can't use acquitted conduct to calculate the guidelines, but you can use it for 3553A factors. In other words, if you're considering sentencing outside of the guideline range, departing upward or downward, if that would even be possible for acquitted conduct. But the problem still is there, that acquitted conduct still can be considered, but really for purposes of an upward departure. So what I expect is going to happen is that we are going to see some more upward departures in the few cases. Now, granted, this affects very few cases, but why I think this is nonetheless important for your listeners and viewers to pay attention to is, as we've discussed and we've written articles on this too, I think that this has much broader implications than just acquitted conduct. That the reason why acquitted conduct should not be included in relevant conduct and really shouldn't be considered at all for sentencing purposes.
Yeah.
That's the same argument. Basically, the constitutionality of it holds for uncharged and dismissed conduct as well. I've always been in the position that only convicted conduct and conduct that surrounds that convicted conduct, or that's part of that convicted conduct, I should say, should be considered. So at any rate, the point simply is this is a small step in the right direction that could have some massive implications down the road. So it's something to pay attention to. The second one, this is really interesting. This has to do with basically, for the legal scholar nerds out there, that are interested in the interplay between administrative law and criminal law. This is
Yeah.
what this next issue is.
We did a whole episode on that too, I think.
Right. Yes,
We'll
we
have to
did.
put all those in the show notes, but go ahead.
Yeah. So basically, back in 2019, the Supreme Court held in this case called Kisor versus Wilkie, Kisor, that when when a court is reviewing an agency's interpretation of its own regulations, that it should not give that agency's interpretation any deference if the regulations are unambiguous. And so let me put that in less abstract terms. Many courts have now applied it to the guidelines, and the commission obviously thinks it applies to the guidelines. And the courts that apply that principle in Kisor to the guidelines have found and this is a very specific issue. It has to do with loss. So under 2B1.1, there is a definition of loss that involves, there are two types of loss. There's actual loss, which is the run-of-the-mill basic understanding that we all have of what loss is. You know, if you lose money, I lost $500,000 to this fraud or something like that. Actual loss. But there's something else called intended loss, which is very different. Intended loss doesn't encompass, obviously, actual loss. It's what the defendant may have intended to steal as part of whatever fraud the defendant was participating in. So it's not an actual measure of harm or anything. It's more a measure of the defendant's intent, whereas actual loss is a measure of the harm that was caused by the offense conduct. So there were two very different things, actual loss and intended loss. But what the guidelines have always said is you use the greater of those two. Now, that definition of loss occurs in the commission's commentary or the commentary to the guidelines. And so what many courts have said that have applied Kisor to the guidelines is that the term loss, which it's not defined, but it occurs within the guideline proper, within 2B1.1. You say, look, it's unambiguous. We all know what loss means. So because it's unambiguous, according to Kisor, we can't defer now to the agency's regulation, in this case, to the commission's commentary at the bottom. And so because we can't defer to that, then you can't use intended loss, because the only place that intended loss occurs is down there in the commentary. And so the Third Circuit went that way. The Sixth Circuit kind of went that way, but found that loss was ambiguous. And there are many different findings, but most circuits, except the 10th, I believe, has found that Kisor applies to the guidelines. So this resulted in a split in the circuits about whether you can use, intended loss or not. And why this is big is in fraud cases, which are the fourth most prosecuted type of federal offenses or fraud cases, the government always wants to use intended loss. Why? Because it's easier to prove, because really there's nothing to prove in intended loss. You don't have to prove any actual loss or any actual victims or anything like that. It's just a made up number that you can go there to inflate the guidelines, and you get a crazy sentence.
Yeah.
So what the commission has done is it decided to resolve this circuit split about whether or not you can use intended loss or not. And it did it in a kind of a, not a sneaky way, but almost, it kind of has the ooh factor to me, because it's a very unprincipled way they resolved this. They resolved it in a way to get to the resolution they wanted, as opposed to utilizing some principle in amending the guidelines. And what they did is they just said, oh, well, if it's in the commentary and you can't defer to the commentary because loss is unambiguous, well, we're just going to move that up from the commentary and put it right into the guideline itself. And that's what they did. And so now they say, okay, all that stuff about Kisor and everything, at least as it pertains to loss and intended loss and all that stuff, we've resolved it, because now the definition of loss is in the guidelines, and it says to use the greater of actual or intended loss. So first of all, I think that's kind of an unprincipled ad hoc approach. Right. Are they going to do that to all the guidelines now? And is all commentary going to disappear? Because there's a lot of friggin' commentary in the guidelines.
Well, and isn't it sort of at least a tacit admission on the commission's part that we're right about Kisor? and that you
Yes,
can't rely on the commentary because
yes,
if they didn't think that was an issue, they wouldn't have had cause to move it.
exactly.
Which, although that's not going to help us for loss, it's could help us for a whole bunch of other guidelines that have really bad stuff in the commentary.
Right. Yeah, but there are also other guidelines that refer to the loss table and to the definition of loss, but refer to it down in their commentary. 2C 1.1, for example, the bribery guideline. All the definition of loss occurs in the commentary.
Huh.
So
Okay.
yeah, so they may have solved one problem, but they've left a bunch of others
Yeah.
unsolved, and there are other guidelines too that refer to the loss table too. And then what
Well,
about
so
tax? What about the tax loss and all this other stuff too?
you're
So
right. I mean, I think the takeaway is keep your eyes on the commentary, whatever guideline you're under. If you've got some problematic language in the commentary, you might be in good shape with Kisor.
right, right.
So
So,
don't let
but
that
there's
go.
one little wrinkle to this though that I think everybody should pay attention to, and this has to do with compassionate release of all things. So that last year the commission amended the compassionate release guideline at 1B 1.13 and added a bunch of stuff, a bunch of new criteria, really expanded the criteria of what grounds can constitute, what could constitute grounds for compassionate release. And one of them was a 1B 1.13 B6, Bravo 6. And that guideline said you can consider a change in law. If the defendant has already served 10 years, you can consider a non-retroactive change in law that, had it applied today, would have resulted in a much lower sentence. You can consider that as an extraordinary and compelling reason for granting compassionate release. Well, the government has not liked that. The government has come out and has been litigating the hell out of that in every circuit, at least that I'm aware of, and has said that the commission overreached on that. As a matter of fact, when that passed, that was the one amendment to the guideline that was not unanimous. And I cannot remember a guideline in recent memory, actually at all, I'm sure there are some, where an amendment passed that was not unanimous. And this particular one B 1.13 B6 was not unanimous. So it passed 4-3.
Mhm.
The four left-leaning commissioners passed it, and the three right conservative conservative commissioners dissented, and they said this was this was basically beyond the ability of the authority of the commission to do this, because what they were basically doing was overriding Congress. And I won't get into the weeds on this, but one of the big things that they noted, and others have noted, is that what the commission is doing now is, and it's something that's always done, but now there's a spotlight on it, is resolving circuit splits. I
Mhm.
thought the Supreme Court was the only entity that could resolve circuit splits. And so really what the government is doing, and arguing that 1B 1.13 B6 is ultra vires or outside the commission's authority, is saying that the commission is acting like a Supreme Court or a junior varsity Supreme Court and can't do that anymore. And I think they're right. And I think
Hmm.
they're right. So what that means is this in other the commission cannot on its own accord resolve circuit splits. Congress could do that. Congress can change the law,
Yeah.
but the commission can't. And so what that means is this little workaround for intended loss, illegitimate, because they're resolving a circuit split. They're acting like a junior varsity Supreme Court. Can't do that. The ghost of Scalia comes up and says this.
Well,
So
but Congress, I mean, you can make the argument that Congress really is the one changing the law here because they have the final say in whether these guidelines are ratified. So, and by their silence, they're ratifying them. So isn't Congress actually resolving the circuit split in that
But
instance?
right. That's certainly the argument that the losing side has been making.
Mm.
The losing side.
Yeah.
But
Okay.
so,
Are you calling me a loser?
no. I'm just saying. I mean,
I feel like you're calling me
and
a
Fred,
loser.
I'm not, and I'm not convinced by that too, because you know, ratification is an affirmation, and Congress is doing nothing. Congress is not affirming; it's just doing nothing
Yeah.
for those 6 months, and that's when the guidelines are proposed.
Yeah.
So the way that the guidelines go into effect, the commission has to send them to Congress to think about for 6 months, and if they do, or is it six? It's less than 6 months, whatever it is. They send it to them on, I think, May 1, and yeah, that's 6 months, right? And then if nothing happens on November 1, then they go into effect. So the Congress basically does nothing.
Well,
So,
and not for nothing, the Supreme Court's doing pretty much nothing too, and the relevant conduct is a perfect example of that.
yeah.
They had the opportunity, they had those cases in front of them for quite some time. They
Oh
had the
yeah, the
option
acquitted conduct.
to resolve that circuit split, and they just
Right.
punted. So
Right.
the commission had to do it, I guess. Well,
Well, that was for relevant conduct, but this is
yeah,
a
but
kind of a different issue.
yeah, but I'm
You know,
just saying,
but actually, no.
Congress, nobody, you're saying it's the court's job to resolve circuit splits, but I'm
Yes,
saying you're probably right, but they're not doing their job.
right. They're not doing their
So,
job, and I take back what I was just about to say. I was about to say that the relevant conduct, acquitted conduct issue is a different issue. No, it's not, because basically what the commission has done is overruled every single circuit, because every circuit has ruled that you can use acquitted conduct for calculating the guidelines, that it's constitutional. And now the commission has come out. They can't say it's unconstitutional. They
right.
just said you can't use it anymore for calculating guidelines. And I could see some prosecutor out there arguing, well, ultra vires.
Yeah.
And
Is
we'll
that a
start.
separation of powers problem? I mean,
Yes, that's also separate. That's very good. As a separation of powers problem, also A+.
thank you.
Yeah.
Well, and so we got to circle the square on this because you're saying that this recent litigation on compassionate release that you're talking about might void the commission's Kisor fix, moving the commentary
Yes.
into the guideline proper. Why? How? Why? How would that void?
Because
fix?
they were trying to resolve a circuit split on whether you can use
I see. I
intended
see. I
loss or
see.
not. Yeah.
Okay, but then wouldn't that screw us on relevant conduct is
Yes,
no longer acquitted? It'll
that's what I was just saying. Yes, that's what I was
okay.
just saying.
Gotcha.
It'll screw us there
So
too.
the
You got to take the good with the bad.
give with one hand and take with the other.
That's right.
God,
This is
it's just
and
layers of fuckery.
Yes, but forgive me for saying this, but this is all Kabuki theater, because at the end of the day, you don't have to follow the guidelines. So we go through all of this mess, all
Right.
this. It's kind of like the BOP. We have this messy system that's costing way too much money. And the guidelines are the same thing. We spend all this time litigating about what the freaking guidelines mean, and then at the end of the day, the judges toss it out.
Right.
I don't care. I'm gonna sentence whatever the hell I want.
Yeah.
To varying degrees, and that's the other problem.
But statistically speaking, that generally inures to our benefit, right? Like there's more there's more downward variances because the judges don't have to follow the guidelines than upward.
Well, there are more downward variances, but where it doesn't inure to our benefit is nobody's paying attention to, except me. No one's paying attention to the degree of the variance.
Yeah.
And if this defendant is getting 80% off, why can't your client get 80% off, or this guy get 80% off? Why is this guy only getting 30% off?
Right.
So it's just it's another layer of disparity that even though everyone's getting below the guidelines, the question is how much.
Yep.
So
another layer of disparity under a regime that was meant to eliminate disparity.
It's right.
Super.
The guidelines now are creating not only creating unwarranted disparity, but they are also helping to obfuscate the whole sentencing regime, when part of the purpose of the guidelines was to bring transparency and rationality. Look, this is how we're doing it. This is why I'm giving this defendant a particular sentence. It's not because he's black, or not because she's female, or not because they went to UCLA instead of USC. It's because, here's the loss amount and the number of victims and da 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 da. But none of that shit matters anymore.
Right.
So it's like I keep going back, it's Kabuki Theatre. We're just doing it
Right.
about a Potomkin village, if you will, whatever the
Right.
metaphor.
Which in
It's very
my
frustrating.
mind is really validates the essence of our work at sentencing, which is to say, screw the guidelines. They don't give you any clarity. And by the way, all they're really talking about is the offense conduct. We're talking about holistically, you sentence the person, not the crime. And so it's just I'm like a broken record, and I say it over and over, but I have to keep saying it. Mitigation is everything at sentencing.
Yeah.
Nothing in sentencing makes sense except for a well-developed, well-told mitigation story, period.
Yep.
And you don't get to do that unless you treat that with equal importance as resolving the substantive offenses. So that means you better start early with mitigation.
Mitigation, yes, but part of mitigation is data.
Yeah,
And data don't lie.
right.
Data can be your friend. Data helps. And that's the whole point is okay, these guidelines don't make any sense. Nobody's following them. Okay, what are they getting out there? Well, that's where sentencing stats comes in, where we can provide, defendants and their attorneys with what similarly situated defendants have been getting actually, and why, and how much below the guidelines. And we can find not only those that have the identical sentences to them, or the identical guideline calculations, but also age, race, sex, which actually can matter. Rate, unfortunately, race still matters, and that shouldn't shock anybody. Sex does matter, and that really shouldn't shock anybody. Education matters. Again, that shouldn't be a shocker either out there. So there's a whole bunch of other factors, and also it varies by type of offense. Assaults, those tend to be guideline sentences. Child pornography, those tend to never be guideline sentences. They always get way below the guidelines, believe it or not. People would think, oh my God, child pornography, they're the worst. It's because the
Yep.
guidelines are nuts. But and so on and so forth. So the last
Well,
two.
and by
Oh,
the
go ahead.
way,
Yeah.
just on to further plug your statistics work, you're not necessarily just looking at the guidelines for what they're being sentenced on. You may need to run statistics on guidelines for other seemingly more serious offenses to say,
Yes.
here we have this fraud guideline where the guy's looking at 20 years, but if he would have committed sexual assault or something like really a heinous, violent crime against a person, might be looking at 7 or 8 years,
Right. Exactly.
and,
Yes.
and
Yeah.
those comparisons are pretty important as well.
Right. And
All
we
right.
can also analyze the judge. We can look at your judge's history and what he or she has been doing in these particular cases, and how he or she's been sentencing too. At any rate,
Nice.
so the last two ones here, the last two big changes to the guidelines is I kind of blame myself for this. The clarification to 4C 1.1. 4C 1.1, it was this new amendment to the guidelines that went into effect last year that said if you had 0 criminal history points and you met all 10 criteria, a bunch of criteria, then you get 2 levels off of your overall offense level, which was
This is the
significant.
Zippo,
The Zippo, and we've done several podcasts
zero
about
point
this.
offender. Yeah.
The 0 point offender, yes.
All right. And
So
you came up with a very clear, cohesive, compelling, credible argument that under the old 4C 1.1, role in the offense wasn't going to kill you because of the way it was written. It also had to be a
correct,
serious, like a drug trafficking offense or, yeah.
correct. One of the criteria that said the guideline said is you couldn't have is a role in the offense adjustment while engaged in a continuing criminal enterprise, and continuing criminal enterprise is a term of art for drug trafficking. So if you were a management level drug trafficker, then you couldn't get it. But what the commission said, and many courts were interpreting it as, was just automatically, if you got that role in the offense adjustment, you didn't qualify for the Zippo, which doesn't make any sense empirically, because believe it or not, those with role in the offense adjustments, and what this means is if you are a supervisor, manager, or leader of a conspiracy, you get bumps up for that because you're more culpable. But what's interesting and what it turns out, and this is the commission's published studies, is that those individuals with higher offense level or higher management levels, the higher you go, the less likely you are to recidivate. And that was the whole point of the 0-point offender, was to recognize that those with 0 criminal history points are the least likely to reoffend, so they should get a break. Using that same logic, then a 0-point offender with a role adjustment should get a break too, because they're even less likely to recidivate. But the commission, not being logical or consistent, or just ignoring its own studies, said, hey, we're going to throw this in here and say, if you get a role adjustment while you're committing continuing criminal enterprise, blah, 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 you're not going to be eligible for it. So as you point out, I've
So
always
they
made the
saw
argument.
these great arguments that
Yes.
we've been making for the last year or more,
Yeah.
and they said, "Oh shit, they're probably right. Let's change that."
Right.
So that's
now,
not good. And here's the other problem. The role, it's not that hard to get a role adjustment, and it can be
Right.
between 2 and 4 levels up.
Yeah.
And I think in the past, we fight it, but I think we're going to have to really focus, drill down, and see and think of creative ways to fight that harder. Because if you get a 2-level upward adjustment for role, it's really 4 levels, because you're not getting the -2 for Zippo.
Right.
And if you get a 4 level, you're talking about essentially a 6-level jump
swing
in your guidelines, and that's big. That's a huge, huge jump. And I also have been seeing that prosecutors are using this. They're going out of their way to try to make sure people do get role enhancements, because they don't want them to get the Zippo. So you're going to see them saying, well, we're going to stipulate in this plea agreement to role an adjustment. And, you better think about that and see what the evidence really is there, and see what your odds are of challenging that, because that's a big hit.
Right. It is a big hit. But one thing that you can do, because the guidelines are merely advisory in this Kabuki Theatre world we live in, is you could always argue for a variance. So even if your client does have a role adjustment, I would still make the argument that he should receive a 2-level downward variance, because assuming he otherwise meets the criteria, like he didn't engage in terrorism or a sex offense or something like that.
Right.
Then he should get a downward variance, and cite the commission's empirical research, their studies that say, look, he's less likely to recidivate than somebody that had no role adjustment. Right. And the commission studies, and I'll send it to you so you can put it in the show notes, but the commission study shows in a nice little chart that if you have no role adjustment, you're like this likely to recidivate. But if you're a supervisor, then you're this likely to recidivate. And it goes on down to manager and then leader. So with the leadership role, that +4, you're the least likely to recidivate. And that's the whole point of the 0-point offender.
Well, and it's kind of the relevant conduct, acquitted conduct in reverse. In other words, the guidelines saying, well, you can't use it for the guidelines, but 3553, you can go out, you can use it to go outside. So if you're allowed to do it to go up, you should be allowed to do the exact same thing to go down.
I like that argument. That is very good. Yeah.
What's sauce for the goose?
There you go, man.
Good for the gander, some shit like that. I don't know. It's just so funny how each one of these sides swing this way, and it's like good for us, bad for. I mean, it is. It's Kabuki Theater.
Yeah.
That's not a politically incorrect term, is it? I hope not. Can we still do Kabuki Theater?
Well, yeah, it's traditional Japanese theater, and the term Kabuki theater, and I've researched this.
Okay, good. I don't want to get in trouble.
Yeah,
man.
It's not. Yeah, no. I mean, I haven't seen any instances where anybody's saying that it's a derogatory or racist or culturally inappropriate term or anything like that. There really
somebody will.
Well, really, in a political discourse, what it means is that something is being there's something that is just performative without any substance underneath it. You're doing all of this stuff for nothing, and it's basically to express some type of activity, usually a political activity that masks its emptiness, that there's nothing to it. We're doing all this stuff, kind of like, I don't know, Matt Gaetz being, Trump offering him up as the AG in some type of political theater here to get us all distracted from something when there's nothing there. That's kind of Kabuki Theatre. Oh, look at this. Look at, the red herring out
Did
there.
you hear today though he withdrew his
Yeah, well, that was the point. Yeah, I think that was maybe actually. I think that's a good example that he withdrew because that was probably the point all along. It was just some big distraction or just to throw up some flair to see what would happen, just to get us all in a rile for no purpose.
By the way,
No
a little preview of coming attractions. One of the podcasts we're getting together for the new year is a panel of very awesome experts to talk about what the shape of the DOJ is going to be under the new administration and what we can expect, as federal practitioners coming down the pike. So that's going to be interesting. Maybe
Yeah,
by then we'll have an idea of who the next sucker is in the bucket for the nomination. But
Eric Trump.
nice.
Yeah,
I
that's what
like it.
I don't even joke about that anymore. It's just whatever, however absurd you can think, that's what it's going to be.
Wow.
So, so
All right.
speaking of Eric, let's go to our last point here, which is the youthful offender.
The youthful.
Um, yeah. So
This
this is
is
something.
cool. This was not on my radar. I'm kind of jazzed about this one.
Yeah.
Tell us.
So
This might
so
be
with
the
it,
only real bright spot in this list.
yes, yes, yeah. I agree, and this is something that the commission hasn't paid too much attention to historically. And there's a whole wealth of information, empirical research, et cetera, et cetera, et cetera, that that demonstrates that, especially in males, that our frontal lobes are not fully developed until sometime after our mid 20s, and we're much more impulsive, and have very poor executive decision making and stuff like that when we're under our mid 20s, when we're just, as young adults.
Mm-hmm.
And so that's something that courts should take into consideration, the commission has finally said, for purposes of a downward departure. And this is at 5H 1.1, which traditionally age wasn't supposed to be taken into consideration as a factor. It wasn't ordinarily a factor to consider for purposes of departure. Now the commission has said, quite clearly, that those that are younger, that are under mid 20s, that their youthful nature should be taken into consideration for purposes of a departure, because they could be, much more impulsive. God knows I was.
Mm-hmm.
So, but that's not an excuse. Obviously, we're not looking at to excuse criminal conduct here, but it helps explain it, and it helps to reduce the culpability of a defendant. It's much like you and I have discussed quite a bit, those with, for example, autism, or things, or really severe depression or
Yeah.
anxiety, is some type of either mental illness or defect that's always been taken into consideration by the law, sometimes to excuse conduct like insanity, or to mitigate it, as is the case here. So this is a bright spot. I'm glad that the
Yeah.
commission
Well,
has
and
identified this.
there are states who have youthful offender statutes that even go further and say, that you could be treated as a juvenile even if you're over the age of 18 up to the age of whatever, 22, 25,
Oh,
for this very reason.
yeah,
And they're not often imposed, but they're on the books again because the science tells us your brain is not you're not functioning on all cylinders, right?
right.
And that is mitigating. It's not an excuse for the crime, but it's definitely mitigating. And it's also, we always like to paint these stories of hope and redemption. A judge will want to know, how afraid of your client do I need to be in the future? How much do I have to deter?
Right.
And the science tells us that we grow out of a lot of this stuff. Once our
Yes.
brains fully mature, we make better decisions. And we don't really need a scientific study to know that to be true. Anyone who's been a kid or has a kid knows that to be true. And so we really got to start beating this drum. And you mentioned autism. This is definitely just a sliver of a shadow of the truth about our autistic clients, because if you do testing on them, regardless of their intelligence, their IQ, if you look at their emotional capacities, their social emotional, and their what we call adaptive functioning. In other words,
Mm.
you may be 25, you may be 35, but how well are you able to function in the world? How well are you able to communicate and understand social reciprocal language? And some of these testings will put these folks in the low teens or less. Like
Yeah.
you're talking about 12-year-old, 8-year-old, 12-year-old, 14-year-old kids in 20, 30-year-old bodies. And I have long been banging the drum that this arbitrary cutoff of 18, you magically responsible, perfectly responsible for everything that you do, is absolutely absurd. So this is,
Yeah.
for me, this is definitely the shining star of the guideline amendments.
But just one thing though on the youthful offender on age, and I wish the commission, if anyone at the commission is listening to this, it would be helpful to also consider the other end of the spectrum, those that are really old, the elderly. The elderly offenders, for a very obvious reason, tend not to recidivate either. They
Mm.
grow out of their criminality by dying, and that's something that should take that either dying or because of just age-related illness and etc. You don't see a lot of recidivists that are over the age of 50. And the matter of fact, the Bureau of Prisons considers any inmate that's 50 or older at the time that they're imprisoned to be accelerated aging inmates. And they require a lot more help and resources because of age-related illnesses, et cetera, that they're going to suffer just by virtue of being a human being. And so I think that if we're going to take, as we should, take into consideration the youthfulness of an offender, we should also take into consideration the elderliness of an offender too, for the same
Yeah.
reason. It has to do with culpability and recidivation. Now, maybe a youthful offender, we take that more into consideration because of culpability issues, that they're not as culpable, whereas an older defendant would be more culpable, but their likelihood of recidivating is a lot less. But the point simply is age does matter, and
Yeah.
that is something that should be taken into consideration. And the last little plug is life expectancy.
Right.
And even young defendants, relatively young defendants in their 20s, 30s, 40s, getting 20-year sentences, those can be de facto life sentences.
Yeah.
And throwing people away like that so easily,
Yeah.
the commission really
Well,
needs to start taking a look at that shit.
well, yeah, and it also, the age thing goes into telling the story of prison at sentencing. In other words,
Yeah,
how much more punitive and harsh will a prison sentence be for an elderly offender?
correct.
Because they don't have the resources to care for their medical needs. They're vulnerable to a younger, more predatory population. They tend to be what they call cave dwellers, where they're just sort of hiding in their cell and isolated. There's movement restrictions in almost every single facility, which is you have 10 minutes to get to point A, from
Mm.
point A to point B. Otherwise, there's the discipline action that can follow. Well, how does that work if you're, 70 years old with
Right,
bad hips, bad knees, and you're carrying a big load of laundry or commissary and walking up flights of stairs, and in the snow and whatever else. So it's a
right.
nightmare. I mean, prison's a nightmare in general for anyone, but for certain populations, we tell the story of how terrifying the nightmare will be exponentially. So, what if there's no bottom bunk for an elderly offender and they got to climb up to a top bunk
Right.
every time they want to take a rest? So, we tell those stories, and again, I think they're far more compelling than the Kabuki Theater of the guidelines. I have a
Yes.
totally random question now because my mind is on fire with the autism stuff because we do a lot of these cases. And In one state, Virginia, now they have a law on the books that says if you can show by clear and convincing evidence that autism played a part in your offense, you're eligible for diversion.
Wow.
Wow is right. And, and there's some great organizations that have been lobbying for these, and that was unanimous bipartisan support. So there's a growing understanding of how deeply less culpable, less morally responsible, if not legally responsible, people on the spectrum are in a variety of different kinds of cases. And of course, the most common ones we see are online offenses, child pornography, that sort of stuff.
Mm.
And so I'm thinking about how do you go about lobbying? I know you lobby Congress for changes in the law. How do you lobby the Sentencing Commission
Oh,
to
great
propose
question.
a totally novel, I think it would probably be a tweak to the diminished capacity downward departure that exists in the guidelines, but tell me, like, if I wanted to go on a crusade and say, you got to take a look at this and propose some language.
Well, that's something the commission is really good about is listening to the public at large and every actor within the criminal justice system, whether they're a defendant or an attorney or a judge. So you can go online, go to the U.S. Sentencing Commission's website, and there is a place for public input. That you can do this at any time, but there are some times of the year that are better. So usually in the summertime is probably the best time if you have a new idea or a big change to the guideline you want the commission to consider, because in the summertime is when they come up with their proposed priorities for the coming amendment cycle. And then towards the end of summer, they will publish what their actual proposed priorities are. Then they hear testimony. You can either participate, you go to the commission and participate in one of their public hearings that they'll have there, or you can just participate online and send in commentary while they're considering the proposed amendments. They'll take those priorities and they'll say for example, so you see this website.
Mm-hmm.
Okay,
Yeah.
so here are the proposed priorities for this coming amendment cycle. Simplifying the sentencing guidelines, something that they've been looking at since the beginning. Reduce the cost of unnecessary incarceration. So there's something big. So there's a priority that they're looking at. They want to reduce the cost of unnecessary incarceration. And what's the easiest way to do that? Less inmates. So if you have a proposal about how to lower the guidelines, or you do something to the guidelines so defendants are not as likely to go to prison or for as long. That's something you could propose to the commission now that these are their priorities. And then what they'll do is they take public comment from this. And they also have like a practitioners advisory group and a probation officers advisory group. And then they have the DOJ, of course, weighs into. But all of this is public. You can get everybody's comments. NACDL, nice. Their sentencing committee that I used to be part of, they will send commentary to the commission too on what the commission should do with respect to these priorities. Then what the commission does, looks at everybody's input, and then they'll come up with a proposed amendments. And then again, we get to all discuss these amendments. Usually the commission will give you options on the amendment. You could, option 1 or option 2 or option 3, and everybody gets to comment on those. Then they'll have a final hearing sometime around March, and they'll March or April, and then that's when they'll adopt their final proposed amendments. And then at the end of April, on May 1, if I'm or April 30th or May 1, either one, they'll send their final amendments to Congress, which Congress generally sits on for 6 months. And then on November 1, they become the guidelines. They go into effect. So that happens every year. Nice. It's kind of like clockwork. So you always want to look out. Basically, in the summer is the best time to start. You can send comments or suggestions at any time, but the best time is in the summer.
Well, thank you. That's good to know. That's good to know. They got some work to do there. Yeah. So and Mark knows these things for a lot of reasons, but one of the reasons is because he used to be a staff attorney for the Sentencing Commission way back in the day. So you probably saw this process up close and personal. Pre-Booker, pre 20 years ago. Oy. Okay. I was 14 when the guidelines came out. But you know what's special about that? 40 years, 1984. It's also the year that I picked up the guitar for the first time. So
Nice.
it's been 40 years of guidelines and 40 years of Doug jamming on the guitar.
Well, see, you've gotten better in that period of time. The guidelines have gotten worse.
I'd like to think so, but yeah.
Yeah.
Well,
Yeah.
ideally in this lifetime, we're here to improve, and
Yeah.
I guess that's what we're here doing now. We're gonna help these people up their game, at least
Very
in my
good.
wildest fantasies, because I'm sure the commission, each and every member, is going to be listening to this podcast episode and jumping on all of it. Anyway, well, so this is fun. Great way to end the year of some really great content. And I thank you for contributing not just today, but all throughout these 104 episodes. And we're going to keep having these conversations, and we'll see you guys next year.
That's it for today, but before we go, I just wanted to take a moment and say thank you to you, the listener, for spending time with us today getting set for sentencing. Whether you're a lawyer, someone who could use the help, or maybe you're just a true crime buff who loves the inside scoop on how this whole thing works, I am so glad you're here, and I hope you keep listening. If you're interested in knowing more about what I do, mitigation videos, case consults, live teaching, on-demand educational content, books, articles, all of it, please visit www.dougpassonlaw.com. I'm Doug Passon. Until next time, hang in there. Wait a minute, that's a stupid way to sign off a podcast about sentencing. Hang in there. What's the matter with you, man? I guess they call that gallows humor. Sorry. All right. Well, I will see you next time on Set for Sentencing. Bye-bye.